Good morning, everyone. Those of you who are in the hearing room present and participating, and those of you who are participating virtually, we appreciate your participation today and glad to see you. Today's workshop was noticed by the clerk's office in docket number 2025-191A. The notice of workshop was published on July 10th, 2025. And the notice stated that the commission staff would conduct a workshop today related to the procedural issues contained in Act 41 of 2025. The workshop was scheduled for today in the commission's hearing room. Okay. I think what we'll do first is ask who's present and who and the entity that you may represent. And if you represent yourself, please say that. And then I don't think there's anybody on the list today that's representing himself or herself as an individual. And then I will move to make some comments, everyone. I think that would be helpful, perhaps, before we start. So I'm going to call the names of the entities who are present, and they're based on the order as of the notices of appearance as they appear in the docket. I know we change the methodology every time we meet, but that's what I think is easiest today. So we're going to start with the Office of Regulatory Staff.
Thank you, Ben Mustian. With me today is Andrew Bateman, our Executive Director.
Hi, good morning, Director Bateman and Deputy Director Mustian. Thank you for being here. Okay, then number 2 will be Dominion Energy, South Carolina.
Good morning, Jocelyn. I'm Chad Burgess. I'm in-house corporate counsel for Dominion Energy, South Carolina. With me today is Michael Anselmo from the law firm of McGuire Woods,
okay,
who serves as the company's outside counsel.
Good to see both of you. Number 3, Duke Energy Carolinas, LLC, and Duke Energy Progress, LLC.
Good morning, Ms. Boyd. On behalf of Duke Energy Carolinas and Duke Energy Progress, I'm Sam Wellborn. With me today is Lyle Trawick of the firm Robinson Gray.
Okay, thank you so much for being present and participating. Number 4, South Carolina Department of Consumer Affairs.
Hi, good morning, Jocelyn. Roger Hall on behalf of the department.
Good to see you, Mr. Hall. Number 5, Lockhart Power Company informed us in writing that they probably would not be participating today. Number 6, South Carolina Public Service Authority, Santee Cooper.
Good morning. Stephen Pelcher, attorney for Santee Cooper. And Megan Driggers will be coming in here in a little bit.
Oh, will she? Well, you have a busy day today here. Good to see you, Mr. Pelcher. All right, number 7, Southern Environmental Law Center.
Thomas Gooding with the Southern Environmental Law Center. I'm joined by my co-counsel, Kate Mixon.
Good morning, Mr. Gooding and Ms. Mixon. Thank you for participating. Number 8, Nexus Water Companies, South Carolina Utilities.
Good morning, Charlie Terani for Nexus Water Company.
Good morning, Mr. Terani. And next, Palmetto Broadband Coalition.
Good morning, Ms. Boyd. Brad Wright and Peg Fox with Burr Foreman Law Firm on behalf of the Palmetto Broadband Coalition.
Good morning. Thank you for being present and participating. And last but not least, Piedmont Natural Gas Company, Incorporated.
Good morning, Ms. Boyd. Jason Richardson, the law firm McGuire Woods, outside counsel for Piedmont Natural Gas Company.
Okay, thank you very much, Mr. Richardson. So everyone knows, I'm sure, why we're here today. We kind of started this process a little bit on June 1st for the regulatory process forum, and some comments were made regarding procedural requirements of Act 41. And then the commission voted in order number 2025-391 for the commission staff to initiate a workshop regarding the procedural requirements of Act 41. And then the notice proceeding today, notice workshop for today. So a couple things I wanted to mention before you start. Everyone begins with their comments. First, staff agrees with the comment about deleting the sentence that says a contested case shall not include a formal individual complaint docket. So take with that what you will. Do with that what you will, okay? Next, I think Mr. Anselmo, you asked on 103-846, why did and you can blame all this on me. This is something, what I was trying to do, we heard the concerns on June 1st. So we're trying to issue a notice, but also include something substantive for people to consider, participants to consider. And so did not want to issue the notice without at least some recommendations, okay? But On 846, where it says, and in compliance with the governing laws of the commission, and I don't know if it was you or if it was Duke, I just can't remember. Someone said, well, maybe that should be changed to the regulations. Was that you, Miss? Okay, that was Palmetto Broadband Coalition. So the reference there is in reference to the signature and verification regulation. We'll get back. We will return to that topic in just a minute, Mr. Anselmo. But I wanted to mention that, and I think the rest of it. I mean, we of course want to hear what your comments are, but I thought it was important to mention those two topics before we start. Let's see what's next. Contested case. Okay, I emailed you. You should have received an email for docket number 191 today. Just comments as we staff perceive them based on what Mr. Anselmo, you filed. Duke Energy Carolinas and Duke Energy Progress, you already had a strike through and underline, so I didn't. And then Mr. Terraini, based on what you filed for your client, Nexus Water Group, you should see a document in your email. And then Mr. Wright and Ms. Fox, hopefully you saw the document just based on our view. We could be wrong or right. Ms. Purvis, am I talking too closely? Okay. Then I also emailed one other document. It says additional topics at the top. And just so everyone understands, I think we're probably going to have a follow-up workshop, but I needed to bring those topics, and I'll tell you a little bit why they are listed, topics 1 through 4. Okay, we'll get to that after everyone presents their comments. Okay, so how does everyone feel? Does anyone object to calling? Let's see, who's first? Who would be first? So Dominion Energy South Carolina filed second, as its notice of appearance second in the docket. So we would call on Dominion Energy first, and then I would ask in the order if anyone has any comments at this time. Does that make sense? So Mr. Anselmo perhaps would provide his comments, and then I would begin with the Office of Regulatory Staff and say, Office of Regulatory Staff, do you have anything at this time you would like to say? And then I would move on to Duke Energy Carolinas. Does that make sense? And then the next entity that filed written comments would be Duke Energy Carolinas. So Mr. Trawick or Mr. Wellborn, if you would summarize or present your comments, and then I would go back to the Office of Regulatory Staff. Do you have any comments based on Duke's comments? Does anyone have an issue with that order for today? Okay. So Mr. Anselmo, we'll start with you. Do you need any of this equipment over here, or are you?
No, I'm going to hang here today if that's all right with you.
Yes, sir.
I think our comments overall were pretty straightforward in this one, so I won't rehash them. And to the extent that Jocelyn, you as staff representative has questions on our particular ones, just please interrupt me, and I'll be happy to address them.
Okay.
The summary on our point on 803, 832, the subpoena rule is we think this is already covered by existing commission regulation and the interplay with the rules of civil procedure. So while we understand the discussion about this, it seems that we don't need to reinvent the wheel because it's already covered. So we would suggest striking the proposed addition and just leaving the rule as is. I mean, frankly, subpoena practice isn't a big thing here. It can lead to abuse in some instances, and I think the normal course of business is probably better than introducing a new avenue. We had various comments in Reg 833 about the discovery procedural schedule revisions. I think our comment for subsection B and C is straightforward. Really, in our comments, the written bolded italicized language were our additions. We didn't propose changing anything that staff had proposed, but what we said was let's put in the language from Act 41 about the actual milestones that are supposed to be covered. So I didn't draft that language, the General Assembly did, and I just plopped it into B and C. I think that meets the intent of what the General Assembly is trying to do, not even the intent, the plain language of Act 41. Then we move into the 20-day timeline to respond to interrogatories and requests for productions of documents and things. I think, again, I covered in depth why But the short answer is every civil court or forum in the state has a minimum of 30 days for a party to respond to these things. The commission already has the shortest, most time frame to respond. The company receive a lot of discovery and ORS's data requests. 20 is hard to do it, to meet in any way, but we work diligently to do it. So all we're really asking there is to leave the 20 days, but cognizant of the fact that some dockets you might be able to move faster, or it doesn't necessarily make sense to have to, in a procedural schedule, to string it along.
Mm-hmm.
I think the party with the burden of proof should have the opportunity to waive that and respond and shorten the time frames as they see fit. They have the burden. If they want to move it along faster in conjunction with the other parties, they should be able to. So we proposed that addition as well. And one thing, I had a typo in mine on page 8 in 833B, where we're talking about the party with the burden of proof being able to shorten the time period. My bolded italicized language was the addition, and then there's an and that leads into what already exists in the reg, the commission's ability to shorten or extend the time periods. That really should be an or. I did not intend for that to be a two-step process.
Okay.
I mean, if the party with the burden of proof says, and everybody in the case says, yeah, we'll shorten the deadlines because this docket makes sense to do so, we really shouldn't have to come to the commission. That'd be counterintuitive. And then you'd already be outside of the 20 days anyway by the time it ended up on a... So that really should be an or. I inadvertently put an and, didn't catch it till this morning. The deposition reg mirrors much like what we said in the subpoena. This is already covered in the existing regulation, the process for depositions. It's a discretionary thing in the current practice before the commission, where we have to get permission to take the deposition. We didn't see the need to have a discretionary, possibly non-existent deadline in a procedural schedule when one doesn't exist. The way I think these things would come to the commission would be in the context of reviewing discovery responses. A party might be like, hang on a minute, we might need to flesh this out in a deposition like you would do in circuit court. And then you'd come to the commission outside of the procedural schedule and say, hey, look, we need to take this deposition. But to include an unknown and possibly irrelevant deadline in the procedural schedule seems unnecessary. 835, I believe the document circulated today added this. It appeared that the et cetera in the draft regulation was a reference to other matters, which would include customer matters in the procedural schedule. So we added language about the failure to comply with that could result in dismissal. 842, nothing there. 845, supplemental testimony and responsive testimony. Short version is the proposed language seemed more constrictive than what Act 41 authorized. So the additions to to the regulation, proposed regulation change, is to align with Act 41. You cannot shrink the scope of a statute and a regulation. So in order to conform with Act 41, we think you need to add that addition. 846, the evidence rule. I appreciate your clarification this morning about signature and verification regulations. If that's the intent, perhaps let's just say that. Otherwise, the company's suggestion would be to strike it in its entirety because the initial regulation has been around forever, aligns with what's in the APA. But to the extent it's signature and verification, completely understand that. I don't think we have any issue with that specific inclusion if we limit it in such a fashion. The new reg 817.2 about site visits. I had an initial question on this, and it really is our comment. Was it the commission's intent that this posted 5-day notice would be the first time anybody ever heard of a request to go see a facility? Or
no,
it was not.
It was just to basically, we wanted, considering being transparent to the public, if we are like the commissioners, when they are traveling to NARUC, we have a calendar for the public to know where the commissioners are on commission business. And so that's what the purpose would be for this 5 days, the 5 business days. I just took from the allowable ex parte communication briefing requirement, but it was just to notify the public, look, this is where some of the commissioners or staff are visiting today.
All right. If the regulation stays as drafted, I think we had also, and some others had proposed that perhaps it's unnecessary since the act itself defines the requirements. But if it's merely a notice statute after commission and others have complied with Act 41, I don't think there's any particular issue with it. But I think it might need to, now that we're talking about it, and I'll think about this as others talk, may need to be a little more clear that this is just sort of the public notice reg rather than the notice reg itself, because as drafted, it does lead to confusion as to what the first step in such a request for a site visit would be.
Mr. Anselmo, may I ask you a question? Do you, on behalf of your client, do you think that we need to consider defining what's a site visit and what's an educational tour?
It's a good question. And frankly, I hadn't considered it, so I might want to think before I speak. But site visit versus educational visit, I don't really know if there's much of a distinction, frankly. I mean, when you're going to the site, you're just looking around to educate yourself on like the status of construction or whatnot. But let me come back to that if you don't mind. I hadn't really considered that. That's a good point. Perhaps others who are staring at me intently have thoughts on it as they present it. And then obviously we have continued a dialogue with staff on customer complaints.
Oh, yes.
And others have joined in some of the comments, but given that we have, I think, a little bit of a limited time today, I would like the commission staff to think about what we're suggesting here. This is just not the same thing as a civil complaint where it's mere allegations. It is testimonial. And then having the company not motion to dismiss be viewed under a 12B6 standard is probably actually incorrect at this point, because it's not a motion. It's not truly a motion to dismiss a complaint. You're talking about testimony. So what we propose, and I won't go into all the details, is we think a better streamlined process that preserves due process for all parties, helps the commission move these along, and probably helps the customer understand what they're getting into a little bit better. To the extent you have questions about that after everybody else is done, I'm happy to get into it. But I think the comments speak for themselves.
So would you like for staff to consider maybe at our follow-up workshop procedure, a modified procedure based on your comments that we can maybe get feedback on for the customer complaints?
I think it would benefit if the parties here want to participate in that too, to have a little bit more of a dialogue on this. We're not trying to shrink anybody's access to the court or anything like that, but I would welcome other people's thoughts on a more efficient way to resolve these customer complaints that save other customers money. These are expensive proceedings. So another forum to discuss this, I think, would be helpful.
Okay. Thank you. Is that it for right now, Mr. Anselmo?
You think so? Yep, that's all I had for now.
Okay, all right. So now we will move Mr. Musjid.
Thanks, Jocelyn. So first of all, Act 41, obviously there's a lot to unpack, so we appreciate y'all having these workshops. I think this is very helpful for us to work through these issues in addition to the regulations that y'all proposed. I don't think I had any real concerns with what Mr. Anselmo said. With respect to the interrogatories and RFPs, we typically seek information under 58.455. I know we'll have some further discussion about that later on today, but just did want to go ahead and point that out. With respect to the allowable ex parte, the 817.2, and this wasn't really discussed by Mr. Anselmo, but did just want to say, there's a lot in conducting a site visit under this, a lot of logistical issues. And I know that we've talked about that recently in a status conference. Things like, simple things like security, travel, what needs to happen in order to allow the commissioners to go there. I think there's a question, the way the statute reads, as I read it, especially with educational tours, it talks about utility plants and other facilities. I have at least just read that to mean utility plant and other utility facilities.
Okay.
Or does that mean other facilities generally? And I would welcome if anybody else has comments on that. But that's a question. And in addition, I think there's some things that we've been kind of thinking through, and I guess it would really be up to the commission, but how does that interplay with FOIA and with, if there's a quorum of commissioners, does that make it a public hearing? Does it have to be noticed? Does it have to be open to the public? Which can be done, or if the commission does it in, say, 3, 2, and 2, then from our standpoint, as far as the certifier, would we, if I was the certifier, would I go around and do 3 tours, one after the other, or would we need to send 3 designees? So, there's certainly ways to work through all of those things. And I think there's a way we can all kind of work out what are the different issues, and there may be other issues. So I say all that just to say, I think maybe that particular issue, it may be useful to have another workshop just to work through, because, obviously the statute allows it. I think it would just be helpful, since this is a new section, a new procedure to get input from the parties who are going to be conducting these, and from us who will be the certifiers, just so that we all kind of have an agreement on, okay, here's generally how these things are going to work. Obviously, it will be tweaked depending on the situation, but just so that we're all on the same page, so that we have worked that out on the front end, as opposed to trying to figure it out on the back end or close to time. So that's my recommendation on that.
Perfect. Thank you. Thank you, Mr. Muschamp. Duke Energy Carolinas.
Good morning, Ms. Boyd, and
morning.
thanks again on behalf of the companies for all the hard work your staff has put into these regulations as we all wrestle with Act 41. Nothing to comment thus far on anything Mr. Anselmo said on behalf of Dominion, and we'll reserve our comments for explaining our own.
All right.
Thank you.
Mr. Hall.
Good morning, Jocelyn.
Good morning.
And it's a little awkward. I might just
okay.
put forward if that's all right.
Yes, that's fine. That's fine.
Like everybody else says, the department definitely appreciates the effort of the commission in addressing Act 41, which is obviously a large bill and a lot to unpack. So I guess just responding to what Mr. Anselmo said on behalf of Dominion so far, and also happy to hear that the PSC agrees. The department did agree that complaints are contested cases under the APA, so glad to hear that change. We also agree with Dominion that the 20-day default for discovery responses should remain in the regulations. We recognize that the time period could be shortened, as the PSC has done for certain phases recently, but we also would encourage the commission to consider allowing more than 10 days between testimonies and hearings to accomplish discovery in that shortened time frame already. Let's see, just again, trying to respond to Mr. Anselmo. We also agree that depositions do not need to be a part of the discovery schedule. Let's see. The department does believe that some of the provisions proposed by Dominion around responsive testimony, particularly giving the sole discretion to the utilities, might be a bit of an overbroad interpretation of Act 41. It does contemplate supplemental testimony. I think Dominion's comments also noted that responsive testimony is filed. The statute still contemplates, or I think, a preference for pre-filed testimony. We do recognize that there could be potentially appropriate responsive testimony on a case-by-case basis. But we don't know that should be memorialized as a right necessarily. I think can address it when Duke's comments are raised, but I believe their proposal was more on if new matters come up in surrebuttal or during the course of a hearing. So we think that's a more appropriate reading. And for now, for just responding to Dominion, that's all I have.
That's all you have? Okay. And we'll make a note about what you said about the 10 days between the rebuttal, I guess. I know there's someone has a comment. I think it's Mr. Trawick and Mr. Wellborn next about rebuttal testimony. But regardless, whatever the last testimony that's filed, you're asking for at least 11 days. I think you said more than 10 days. Well, between the hearing and the if we can.
Right, and we recognize that the 6 months to complete a rate case is difficult, and recognize that there's a lot that needs to be done on the front end by all the parties. But right, I mean, if rebuttal is required, and this is something that would obviously benefit the utilities, but we don't mind that. And same between rebuttal and rebuttal. I mean, again, it's just as much time as possible. I mean, it's just I think some of the comments that were filed previously on that, note that you're going to need to be reading testimony, deciding your discovery, drafting that discovery, and getting it out within a couple of days, and then understanding what that discovery says to prepare for a hearing or to prepare your next round of testimony. So just to the extent any additional time can be allowed, we appreciate that consideration.
All right.
Ms. Boyd, I skipped over mentioning my rationale as to why I included that language about the discretion.
For the responsive testimony?
Yeah, so Act 41, I mean, it just says the party with the burden of proof must be permitted to open and close the case, including the presentation of responsive witness testimony. So the suggestion about sole discretion is to indicate that there is no motions practice or commission approval necessary. The Act says we get to do it, period. So I didn't want to think that the maybe as drafted language would then contemplate motions practice or commission approval. The General Assembly said that's not needed. So there might be a more artful way to do it, but that is the intent as to why it was included.
Thank you. All right, let's see. Mr. Pelcher?
Thank you.
Yes, sir.
The only thing that I'd like to comment on at this time is the section 103-817.2 dealing with allowable ex parte briefings, and specifically the language around the educational tours and visits to utility facilities. That, of course, this provision right here, of course, springs from Act 41. We've had an opportunity to kind of look at that recently, and I agree with Ben Mustin there that we probably should have a separate workshop just on that. I will say that when we read that long sentence, there's different ways that it could be interpreted among people of good faith. I've argued with myself about it and my colleagues about it. Among the issues that are out there, when they talk about an educational tour of a utility or a public service authority, the question is, what's an educational tour? When I read that, my imagination told me that the utility would initiate an educational tour and make an offer to the commission to visit. That's the way I saw it. Other people may look at it as the commission initiating the educational tour. We want to show up and tour your facility. So I think I think we have to look at that issue right there, whether the educational tour is something that is initiated by the utility or by the commission or both. The other part of it, and again, I've had conversations with people and taken different positions on it when they talk about a site visit of a utility or public service facility under construction. In my mind, that word under construction modifies the word utility facility. That is, if the facility is not under construction, then it doesn't apply. And likewise, if the facility is already constructed, it doesn't apply. And I don't know what the intent of the General Assembly may have been there, but a possible intent could have been that once there's construction activity going on, that the commission may want to visit to see how it's going. So, in any case, I think that's these are not definitive interpretations on my part, but I do think that it does indicate that we probably should take that language, kind of unpack it, maybe have a workshop on it. Thank you.
Thank you. Ms. Mixon or Mr. Gooding?
Thank you. We do not have comments at this time, but we do look forward to providing follow-up comments in light of what's discussed today.
Wonderful. Thank you. Mr. Gooding, do you want me to call on you again today?
Be great. Yes. Thanks.
Okay, I will. Okay. Mr. Terani?
Thank you. We've addressed some of these things in some of these topics in our comments, so I won't go into detail, but we do have a different take on the subpoena rule. We think it probably needs to be changed, and I'll discuss that later. As to the discovery timelines, I generally agree with what Dominion is saying about the timelines, but I also would agree with Mr. Hall that the 20-day default needs to remain in the regulation, because there just needs to be a default position on when discovery needs to be answered. But I also think the commission's going to need to tailor discovery response times according to the needs of a particular case. And that's not necessarily a discretionary thing on the applicant's position. Depositions, we don't think there's a need for procedurals, for a slot in the procedural schedules for definitions, so we agree with that. I agree with what everybody has said about needing a separate forum to figure out what this site visit provision means, so that it can be implemented particularly. As for responsive testimony, I also agree with Dominion that the act seems to complicate, or the act says it's a matter of right. On the other hand, I think it could be reasonable for the commission to know, or to ask to know, or to set a schedule for when it will occur. For instance, in cases that we've had historically with customer complaints, customer testimony in our rate cases, typically we've said we're going to file some written comments in response to whatever was said at the latest public hearing. And the commission knows it's coming, the other parties know it's coming, and then so we file our comments and other parties can respond to them. I just think it's probably appropriate for everybody just to know when these things are coming. Other than that, that's all I have.
And so, Mr. Terani, one other follow-up question on the responsive testimony. Okay, I understand what you mean with the customer public hearing testimony. But what you're saying, of course, would not apply during a case, like in the middle of a case when a party, they wouldn't file it, but they may need to present a witness. So
absolutely.
Okay.
I think you've got to be flexible.
Okay.
But and so if something comes up in a case that hadn't been addressed in pre-filed, you have a right to respond to it. I mean, that's happened in cases I've had, and the commission's always allowed it. I think that's fine. Oh, and one more thing. I also agree with Dominion that there's a need, we probably need to have a separate forum to address customer complaints. And we've mentioned this before, I think there's a need for a uniform, maybe uniformity, I'm not sure, but we would like to see the customer complaint process streamlined for water and wastewater utilities and not require a full hearing before the commission.
Thank you. I'm writing. All right. Mr. Wright. Oh, Ms. Fox. Okay.
There it is. Thank you, Jocelyn. So we're generally in agreement with a lot of those concepts as well, and specifically in 833, retaining the 20 days for the interrogatories and the request for production, we definitely agree with that. One minor thing there with Dominion's language is this, unless a shorter time period is agreed to by the party with the burden of proof. We think that ought to be by the party receiving the interrogatories or the request for production, because you wouldn't want, it's just kind of arbitrary or random to have the party with the burden of proof agreeing to shorten the time for interrogatories that were served on a different party. So we would just, that's just a maybe a little wordsmithing there. The other thing, most of the areas where we differ a little bit will be covered in our own comments, but I did want to mention that with supplemental testimony, we don't necessarily agree with that analysis that only the party with the burden of proof has the right to reply to response or supplemental testimony. We think Act 41 itself says if something new arises and there is supplemental testimony allowed, parties have the right to respond to that. And I think we might be kind of conflating or getting a little confused with the moving party's right to close the case and have the last word, which I don't think we disagree with that. But when it comes to supplemental testimony, I don't think that necessarily means that only the party with the burden of proof has the right to respond to supplemental testimony. We think Act 41 says that all parties have that right. And with that, the rest of our comments will be covered when we have the opportunity to present those.
Thank you so much. And Ms. Fox, I'm making notes on this is the document that was prepared with Dominion Energy South Carolina's notes, but I just made a note for 103-833, the no less than 20 days after the service, that the interrogatory must be responded. That you mentioned it's not necessarily just the party with the burden of proof. I added the party who's responding to the interrogatory. I captured that right? Okay, correctly. All right, let's see. Mr. Richardson?
No additional comments at this time.
No comments at this time. Okay. Mr. Trawick, are you speaking, or Mr. Wellborn?
I am, Ms. Boyd.
Okay, perfect. Yeah. I'm going to, yes, sir, please proceed. I'm going to find your comments online.
Great. Thank you, Ms. Boyd. I think it makes sense to sort of go in order with the draft regs that the commission proposed and kind of run through our comments on those. With 832, we appreciate the commission agreeing with deleting the sentence about contested cases, and with that, we don't have any additional comments on the subpoena regulation. On 103-833, regarding interrogatories and requests for production, we did have a few comments. We thought that the regulations need to be clarified to, comport with Section 2 of Act 41 that requires discovery be completed not less than 10 days prior to the hearing. Mm-hmm. And so we thought that the draft language might have left a little ambiguity on that. And so we proposed a rewrite there to say served in time to be completed, not less than 10 days prior to the date assigned. And so that was primarily our comment there. And then we agree with Dominion and Mr. Attorney and others that leaving the 20 days in as a default is a good thing. It sets the general rule, but there are also exceptions. And we felt like one of those should be unless extended or shortened by the commission for good cause shown, or otherwise upon agreement of the party with the burden of proof. As a practical matter, in the rate cases, we're the ones getting the vast majority of the discovery and in other major proceedings at the commission. And so we felt that that language made the most sense. It's not really us serving on other parties, and certainly I think you would still have flexibility to agree in writing with others, but we felt like tying it to the party with the burden of proof would have been a logical addition there at the end to both subsection B and subsection C of 103-833. Depositions, no further comments on that other than we're in agreement with Dominion that there's no need to include a placeholder for it in every procedural schedule. those are a bit of a rare bird here at the commission. I mean, we've certainly done it before in unique cases, but we think that can remain as it is and sort of come up on a case-by-case basis. Other discovery procedures, we think that one is fine too for 103-835. We added one tiny little addition there to the final sentence, including a proposed timeline for discovery, just for sake of completeness. And I think the due dates that the commission's been circulating contemplates that, and so this sort of just formalizes that, and we felt like would be a good addition. With respect to the order of procedure in 103-842, we had, some decent comments on this. So one thing we've noticed in comment proceedings that it's sort of murky on who gets to file what and when and who goes last. And by comment proceedings, I mean proceedings that the commission...
like DSM, EE.
Sure. Yeah, for example, great example. Or, applications that we file that are, just ORS will file a report in response. Maybe others might weigh in. So, when does that occur? Who gets to go last? And so we feel like on proceedings that under statute for both electrical utilities as well as gas and water and wastewater utilities, under which the commission can decide the case without holding a hearing, that some guidance on the comment schedule would be beneficial, and to make clear, consistent with Act 41, that the applicant gets to go last. That way it's not just sort of Wild Wild West kind of out in there, who gets to go last and who gets the last word.
Okay.
And so one of our initial proposals was to just add a clause to subsection B of that regulation and say, or comments in proceedings decided without a hearing. Upon further reflection with my co-counsel here, that also might have been a little murky because it had other parties go and then the Office of Regulatory Staff go in. But as a practical matter, I feel like they would probably file responsive comments at the same time. Certainly interested to hear if Mr. Mushin has any thoughts on that, about whether they would want to go last in that or go after other parties had commented. But we feel like the applicant should...
And I'm sorry, can you run back over that again just so I make sure I understand?
Yeah, of course. So here in B 1 through 4, it goes applicant, other parties, ORS, applicant. If it's just a comment proceeding, normally it would be ORS and other parties probably filing their comments at the same time. So unless there's some special interest where you would want to see, what another party says first, we think it probably makes sense just to add a subsection D and call this, proceedings decided without a hearing period. Comments will ordinarily be received in the following order: applicant or petitioner, Office of Regulatory Staff, and other parties, applicant or petitioner. And we're happy to send a sort of red line memorializing that. And sorry for the, audible this morning, but with additional time to stew on it, we felt like that might be a little clearer. But the underlying reasoning remaining the same, that we think some guidance and comment proceedings will be beneficial for the parties and the commission.
Mr. Mushin, did you see that? We put it up on the thing here. Okay. Okay.
All right, that's all I've got for 103-842. Now on 103-845, the witnesses. This was probably our where we're spending the most time. We suggested adding a clause, or excuse me, a couple sentences to subsection A of that provision. As the commission and some of the parties here are aware, we've had some concerns in proceedings about this rule about access to counsel. We felt like the commission dealt with it in a very fair, even-handed, and legally sound way in the company's recent IRP proceedings and docket numbers 2023, 8, and 10E. And we just feel like some formal guidance on that in the regulations is necessary so that all of the parties who come before the commission, not just those who are here more than others, know the rules of the road. And when a witness can exercise their constitutional right to access to counsel. And so, with those observations, basically what it would do is formalize this notion of, once you've testified on direct, the chair would excuse you from the stand, and after that, you're allowed to talk with your attorney about matters in the case. And that would be irrespective of whether you're coming back to testify.
Mr. Trey, excuse me 1 minute. Mr. On the camera on Mr. Treywick is fine. Yeah, thank you. Excuse me. Thank you.
Thanks.
Thank you.
And irrespective of whether you're coming back, but if you do come back in rebuttal, or what I'll get to in a minute, if you're called for responsive testimony to respond to new matters that have arisen at the hearing, the chair would re-swear you.
Mm-hmm.
What would remain is the rule in civil practice that if you are on the stand, you are not allowed to discuss the substance of your testimony with your attorney.
Mm-hmm.
So for bathroom breaks or for lunch breaks, or if you're that unlucky witness who has to stay on the stand overnight because we couldn't quite finish that afternoon, and you have to come back in the morning. No discussion regarding the substance of your testimony while you are on the stand. But aside from that, I mean, you can discuss the weather, obviously, or your favorite football team. But aside from that, witnesses should have access to counsel, and there's a lot of sound policy reasons for that, and also the practical. I mean, our witnesses are our employees, and we have to talk about the business of the company. And so that is something we've felt strongly about. We think we've filed affidavits before from the former Chief Justice of South Carolina aligning with our position. And so we've proposed some language to that effect in subsection A that says, after presenting testimony offered to be admitted into evidence in the record, the witness may be excused from the stand and permitted to freely access counsel. The witness shall be resworn if he or she presents testimony at a later phase in the same hearing. So with that, I'll move on to surrebuttal. We think, their case law sort of discusses the parameters of surrebuttal. The practice can sometimes be a little different. So we think sort of clarifying its scope in a regulation here in the witnesses one, it would be beneficial to the commission and the parties and staff, frankly. Clarifying that it may be used only to respond to new matters raised in rebuttal testimony. Because it is admissible at the sole discretion of the commission may limit the scope of surrebuttal that is admitted into the evidentiary record on a case-by-case basis. So that retains your flexibility and discretion that's contemplated under the case law. I think it's Palmetto Alliance case, while also clarifying that it is truly to respond to new matters, not just to get the last word.
So, Mr. Trey, do you think that, for example, the clerk's office, when we prepare a notice of hearing, we just automatically include the surrebuttal testimony deadline unless the commission has ordered another deadline? So are you asking that we change that practice or that we leave it?
I think as a placeholder, folks need to know, like, if it's permissible or if it's warranted, or if you decide to at all.
Mm-hmm.
I think having a date there is probably beneficial, but I don't think that including it in the procedural schedule should be tantamount to this is a right to just say whatever you want at that phase of the case.
I'm following you. Okay.
Unless my esteemed counsel has different thoughts.
Okay.
So we think it's important to clarify that. With regard to supplemental testimony, I think I filed a letter in the regulatory processes forum docket, and then we've also filed some comments here. After time to reflect on it, we don't think a motion for it is always necessarily warranted.
Mm-hmm.
Again, we're in rate cases. It's an easy example. But if you are supplementing your testimony 2 weeks after you file direct testimony,
mm-hmm.
and the other parties still have 60 days to respond, it doesn't seem like it would be necessary to file a motion for leave to do it. They would still have the right to. They wouldn't be prejudiced by it.
Mm-hmm.
They have time to stew on it and the right to respond to it, no due process concerns. So we just think there should be some flexibility there. The commission, as Mr. Anselmo said, I don't necessarily think a motion was required in Act 41. I think it's a logical inference, but we think that the process works right now, and we recommended adding to that other parties of record shall have the right to respond to such supplemental testimony, which is what Act 41 says. I think others in the room have indicated that. Subject to the right of the party with the burden of proof to present responsive testimony. And so on that note, I want to make sure we aren't conflating responsive testimony with supplemental testimony.
Okay.
Supplemental testimony, at least from our perspective, is pre-filed.
Mm-hmm.
Responsive testimony, if time allows, if there's enough time between surrebuttal and the hearing, something Mr. Hall mentioned, we've sort of explained our concerns before with that tight turnaround. because of the motions deadline and lots of other practical concerns with it, and not the least of which is just preparing for the hearing.
May I ask a question? What
Sure.
word would you use to describe a witness who's on the stand? The oath has been administered, and they noticed that morning that the number should be a different number. Is that amending their testimony?
So I think that is consistent with current practice.
It
I mean,
is?
it could be, it's correcting, right?
Okay.
But if it's something that, other parties need time to digest, I mean, oftentimes, Ms. Boyd, I'll tell you, I mean, the parties are collaborative. That amendment will have resulted from a conversation, right?
Yeah.
Hey, we looked at that and this number's off. And so I think if the parties have agreed on it, they should be able to correct from the stand. Or if their
Okay.
title has changed, for instance, that happens with the utilities. People move up or move over. And so, I think that there should still be flexibility to do those sort of ministerial changes or
Okay.
typo corrections
Okay.
from the stand. I think supplemental is more meaty than that.
All right.
It's, hey, a new analysis has come to light.
Okay.
Or, hey, our fundamental ask has changed in the case because of these new developments.
Okay. Thank you.
And so on that note, responsive testimony, we recommended creating a new subsection F. We're in agreement with Dominion. We felt like, although certainly I'm sure unintentionally, we felt like the draft regulation was a little too prescriptive and sort of ran contrary to the right that's now we think has been there under utility services, but is now expressly recognized in Act 41 of the party with the burden of proof to respond to new matters that arise at the hearing. So responsive testimony, in a perfect world, if there's time to pre-file it, there's enough time between the surrebuttal deadline and the hearing, I think there's flexibility to do that. But that's also not required. I think responsive testimony also can, should, and often will take the form of responding to new matters that arise at a hearing. Sometimes the commissioners come up with questions in a different phase of the case after they've had time to think about things. And we need to be able to, as the utility with the burden of proof in that particular setting, need to be able to put up responses to that. Or parties will ask just other witnesses on things that, affect us. And so we need that right, and the General Assembly has enshrined that into law. And so our suggestion with respect to subsection F is to say that the party with the burden of proof may present responsive testimony not only in the form of rebuttal testimony, but also in response to surrebuttal if presented, consistent with its right to close the case. It may but need not be pre-filed. Further, the party with the burden of proof shall have the right to provide live responsive testimony where new matters or testimony arise at the hearing, including new testimony solicited upon cross-examination from the parties or questions from the commission. And so we think that's consistent with both the letter and the spirit of Act 41, and that is our recommendation for 845. 846, we think that's an appropriate catch-all and are fine with that addition and appreciate the commission adding it. The allowable ex parte briefing one, or I guess I'm going to colloquially call it the field trip provision. We think that's not necessary right now. We're in agreement with Dominion on that, but we've also heard the various comments and some of the flags Mr. Mushton made, obviously FOIA and other provisions of law, and agree that follow-up forum on that may be instructive so that we can have time to fully think through that. And then last, with respect to the customer complaint things, certainly heard Dominion's process and proposed process, and we're also fine with another forum to discuss that too, to make sure that we're using our time here efficiently today on Act 41.
Thank you so much.
I do have one other thing, if
Yes,
I may,
sir, Mr.
Ms.
Wilburn.
Boyd. On the additional topics list that was circulated this
Yes.
morning, we have pretty limited feedback, but do have feedback on the signature and verification provisions that
Okay.
the Commission proposes to add, or the Clerk's Office proposes to add, which I think is in line with what Dominion mentioned earlier, so maybe I'm glomming on a bit. But our opinion is that the regulatory need for verification related to facts alleged within filings to the Commission, that requirement would be very prescriptive. There are already rules that apply in this state. I think of South Carolina Rule of Civil Procedure 11, which provides color around what it means for an attorney or counsel to sign a pleading filed with, with a court or administrative body in this state. that the council has read the filing, that to his knowledge, information, and belief, there's good ground to support it. I think of our utilities filings when they are informed by, for example, 30 or 40 different people sort of coming together to prepare a report. It would be extremely burdensome for us to get 40, affidavits verifying the facts pulled from that team of people, and so practically, it would be burdensome to the point of impracticability. But then, two, the rules that already apply under the rules of civil procedure, I think, obviate the need for this addition in 822. There's also the matter of judicially cognizable facts. So if Sam Wellborn files a letter that says the sky is blue, I'm being facetious a little, but would we need to go out and get that filing verified? And so I can think of instances where it would be extremely impracticable and duplicative of requirements that already apply to utilities practice before the commission.
Okay, so Ms. Wellborn, two quick things. What's the rule of civil procedure that you mentioned?
It's Rule 11.
Okay, Rule 11.
Which provides contours again around what it means for counsel to sign a pleading or other filing with.
I'm familiar with that. Okay, so let me ask you this. So, Ms. Purvis, would you display what's on the desk, this regulation? So, this is the current language in the regulation right now. A verification is required if facts are alleged to be within the knowledge of the person filing the pleading. So, and we don't have to, you may want to, everybody, if you don't want to comment today, no problem. We'll just include this as an additional item. Just curious as your thoughts. For example, as you mentioned, if an attorney files a document requesting relief from the commission and a hearing is not scheduled, so no pre-filed testimony is provided or filed with the commission. Are you saying that Rule 11, if the attorney signs the pleading, should basically act as the verification? This is our current regulation. Or should the filing be accompanied with a verification from a non-attorney expert from the company or the entity that's requesting relief?
The best thing I can do right now is, because this is new, is probably for us to take it back.
Yes.
I didn't appreciate that this was already in the regulation, so it's sort of a matter of how do we implement, or does it need to be improved?
I appreciate your ability to jump.
I'm here for it.
Yes, but yeah, that's what we want to talk to everyone about. And I understand the rule 11, but is this regulation correct? Basically, should it read this way? That's what I think we need to talk about.
It's a great question.
Okay. Thank you, though, Mr. Welborn. All right. Mr. Trey, do you have anything else right now?
I do not. Thank you, Ms. Boyd.
No problem. So now we're going to go back to Mr. Muschin.
So I think the only comments that I had were, so with respect to Mr. Trawick's comments on the proceedings decided without a hearing in the order of the parties, and I don't really disagree, I think, with that. The only thing I did want to point out is, so I'm thinking of things like RSA reports, those types of things. The company obviously can respond to things that may be in the report. I just wanted to, there may be times where if the company responds and brings up something that we haven't thought about or haven't considered, we may need to file responsive comments, which obviously y'all can then file reply comments or whatever we want to call it. So I just wanted to make sure I understood there may be kind of another round of comments. Obviously y'all can go last, I get that, but I don't know that what they've proposed would be would restrict that in any way, but that may just be something we need to think through. With respect to rebuttal testimony and new matters raised, and I don't think I disagree with that concept. We think that when we file rebuttal testimony, we have complied with that, and that is what we do. I will say, if it's going to be in a regulation, I think the question I would have is, what is a new matter? And so that could be open for interpretation, and the commission could certainly decide that on a case-by-case basis as they've proposed in there. But, so I'm thinking, for instance, if there's an adjustment, if we in our testimony recommend disallowing an adjustment for whatever reason, the company comes back in and says, well, no, we should make the adjustment because of X, Y, and Z, and then we would file rebuttal testimony either disagreeing with those points. So the point being, is a new matter the adjustment that, or is the new matter the argument raised as to why the adjustment should be made? And so I don't know that all needs to be fleshed out today, but I think we might want to talk about, or maybe unpack a little bit more, what does that mean and what's that context? And maybe it's that the commission can consider it on a case-by-case basis, and we'll just deal with it as it comes up. But did just want to raise that one issue on that.
Oh, you threw for. I'm sorry. It's a long pause there I had. I'm sorry about that. Let's see, Mr. Anselmo.
Thanks. Just briefly on the rebuttal, I think we're all probably in agreement that certainly everybody should be in agreement. Rebuttal is not a right. Mm-hmm. I think just by having a placeholder date, perhaps that has been broadened by some folks to file rebuttal where it's not needed. I don't think you can define it all in a reg like Mr. Mustian was saying about what's new, what's not. Motions practice will accomplish that if a party thinks somebody's violating what appropriate scope of rebuttal is. But I think a clarification of the schedule, footnote, something saying per commission order or whatever, this is not a right, but in the event it's appropriate, here's your deadline, is certainly an acceptable way to do it in a procedural schedule. In Reg 103-842 about burden of proof and who gets to go last, my comments on that were, hey, look, even if it's a paper filing docket or written comment docket, however it is, the Act 41 requirement exists no matter what, right? It's clear it's a mandatory thing. So however that is added to 842, regardless of the type of the docket, the company thinks that needs to be done in order to conform with Act 41. 845, Duke raised some very good points about the access to counsel issue. Mm-hmm. And just from a practical point of view with the new supplemental or mainly responsive testimony, but possibly supplemental, it is a virtual impossibility to draft responsive testimony if you need a witness who testified 3 days ago in a case, but we are not allowed to talk to them to develop the testimony. So basically, you view it as the prohibitions that already exist in the law that Lyle already talked about exist as you present your direct, as you present your rebuttal. In between there, you have free reign to talk about any potential responsive testimony or anything else that comes up in the docket. Once you're off the stand, you're off the stand, and you can talk to your counsel and help them present the case on behalf of the company. So just the clarification that basically the requirement that we can't talk to them stops when they're dismissed from the stand probably needs to be put in there because there has been some confusion about that.
So you agree with the language that's been Ms. Purvis, please.
Yeah, I thought Duke's language was pretty
okay.
Good there.
Right.
And then actually that's all I have.
Okay, thank you. Mr. Hawk?
Thank you. Let's see, I guess I'll start with since Mr. Anselmo just mentioned it too, as far as witnesses and talking to counsel and the rebuttal, comments we've heard, the department doesn't disagree with any of that. We recognize that rebuttal is for new matters, and I think the current practice has worked well. We also agree with Duke's suggestion about consistency in 833B and C. I think as they noted, the language in the current commission proposal for interrogatories, it said answers had to be completed within 10 days of the hearing, and for request to produce, it said requests had to be provided within 10 days. So we're fine with establishing that consistency, that it needs to be completed within a certain amount of time. Again, to our prior comments that, looking at additional time between rebuttal and a hearing, or in between rebuttal and rebuttal. To the responsive testimonies, and I guess just as a caveat, my comments are really primarily focused on rate cases. I understand that things might operate a little bit differently for a complaint case or some of the other dockets we have. My computer went to sleep. Let me get it back up. And I also agree that we shouldn't conflate supplemental and responsive testimony. I think there are two different things. I've heard about supplemental as sort of corrections or additional things that come up. But on responsive, again, I just want to reiterate that this idea that the utility has a right to raise responsive testimony, that I don't think that is found in Act 41. If you look at Act 41, there are two places where it mentions responsive testimony. One is the right to file rebuttal responsive to direct pre-filed testimony, which we're seeing. And then the last sentence, which has been brought up several times, about the party with the burden of proof must be permitted to open and close its case, including presentation of responsive witness testimony. So it's not defined, is all I'm saying. This, by Act 41, I think taking the next step in the regulation, making it a right, goes beyond Act 41. We've seen in rate cases in the past few years where Duke has chosen to present its rebuttal testimony last. So they are closing their case with responsive testimony. If you want to argue, and I'm not taking a position on this today, that if something new comes up in rebuttal or from commissioner questions, whether they have the right to respond to it, again, I'm not taking a position, but again, that's new matters, and we could all argue if something's a new matter. If they put up a witness that starts just rehashing things they already said, then clearly someone should have the right to object. So I think if you're saying they have a right to present responsive testimony, not knowing what that is, again, I think that's a bit overly broad. I think that's all I had on that issue.
Mr. Hall, Ms. Purvis, would you display? Thank you so much. Okay, so can you see this, Mr. Hall?
Is that the Duke proposal?
Yeah.
Yes. And I have it on my computer.
Oh, you do? So, okay, when you said that when you were referring to the responsive testimony, the language that reads the burden with the burden of proof may present, are you saying you have an issue with the may there? The word may?
To the extent it's read to be allowing it, we say it's may versus shall, but oftentimes you interpret a may to give someone the right to do it.
Okay, but were you referring to the second sentence? Further, the party with the burden of proof shall have the right to provide live responsive testimony. Is that where you?
That's a larger concern for me.
That's a larger concern. Okay.
Ms. Boyd?
Yes.
But again, that one does clarify at least new matter. So I think it's better. I just don't know that any of it's needed.
Okay.
I'd be curious to get Mr. Hall's alternative reading of that last sentence from Act 41, which says that the party with the burden of proof must be permitted to close his case, including the presentation of responsive testimony. To me, there's not an alternative reading to its plain meaning that's fleshed out in our proposed regulation.
I think one potential reasonable interpretation of it is exactly like I mentioned, what Duke has done in recent cases that the commission has allowed, and they have presented their rebuttal testimony last. Again, that is the only other time responsive testimony is in this act is responsible when it refers to rebuttal testimony. I'm not saying that's the only interpretation that it could have, but I am saying that to include that 845F it may be unnecessary, and I think it goes beyond what statute says in its plain language. So again,
respectfully, when other parties file surrebuttal testimony or present surrebuttal testimony, or when matters are presented during the case, for example, through cross-examination or commissioner questions, what could it mean but for the party with the burden of proof to present responsive testimony in response to those matters that are raised during the hearing itself? To me, that is not the rote presentation of rebuttal testimony. That's responsive testimony consistent with Act 41's requirement that the party with the burden of proof be permitted to close its case.
I just think first of all, like I said, new matters, I can understand that you could get to that interpretation that if it's a new matter. So if there's going to be anything, it needs to mention new matters or testimony. If there's any new language added, as long as if that's in there, at least we're relatively happy. But again, so prior to the past few years, at least again, I haven't been doing this as long as some folks in this room, you would see where the parties, the utility would put up all of their testimony. They're direct in the rebuttal. Then other parties would put up all their testimony. Recently, that's been changed where it's, okay, the responsive testimony of the company is put up last. I think that's a reasonable interpretation. Could you interpret it the way Mr. Wilborn is? Sure. I just don't know that the regulation giving that right. And if there's an opportunity for it to be pre-filed, it certainly should be pre-filed. If it's something in surrebuttal that you feel the need to respond to, the preference for pre-filed testimony was not removed by Act 41. So I do believe that to the extent it can be pre-filed, it should be pre-filed. It can be presented last. That's fine. Again, to the extent something new comes up, as we know, the commission is inquisitive and asks questions, or things come up on cross-examination. I understand the parties or the utility may be able to respond to that. Just don't know that, and they could move to do so during a hearing under Act 41, and then we can sit there and discuss it, and whether it's a new matter or whether they should have that right. I just don't think that the regulation needs to include that right.
Ms. Boyd, can I make two final points on that? With respect to how it's gone recently, and he's saying we're doing our rebuttal last, but that hasn't truly been last because surrebuttal's gone after. We've set the phases of the case and then reserved the right at the end to recall if necessary. But also just sort of relying on the way practice has been done, I think is anathema to the fact that the General Assembly intended a change in the law. This is a change in the law, and they did not intend a feudal act. And so I think that we've got to give effect to that.
Okay.
Thank you.
I think it's speculative to talk about what the legislature intended. But it's clear there are changes to law. But again, if the commission takes that approach that this is what it means and that's appropriate for the regulation, then we can, handle that through a regulatory process or decide whether that's the intent or not. Our position is that is maybe just a step too far with the proposal from Duke.
Would you consider it like F? Would you consider filing? Are you saying that you don't think that Section F should exist at all, or
I don't think it's necessary.
Oh, okay.
I mean, clearly we have a disagreement as to what Act 41 means, so some regulatory clarity could be useful here.
Yeah.
And we've proposed that. I don't think the DCA filed any comments. So
I was just going to ask Mr. Hall if you had a different one, if you would file it just so that we could look at it. But if you don't, that's of course not an issue. Okay.
So that's all I had.
That's
I guess
all
for that issue, I did have a question. I don't know. Maybe it's been clarified. There's a reference in Duke's comments to 845E. That something was consistent. I don't know that there was an 845E proposed by the commission.
No, Mr. Hall, that would be with our rewrite. We kind of re-lettered those with the new proposed sections because we thought it would be more logical to have surrebuttal as D. Does that make sense?
Yeah, I may have just misread this. I'll double check it. I don't think it's that important for today's discussion. Just lastly, since it's been brought up, I don't know that, I guess Mr. Chadwick did bring it up. But for the ex parte briefings, I do agree with Duke and ORS that a follow-up form would be appropriate. And I also read it the same way as Mr. Mushton, that these site visits or tours should be for utility facilities only.
Okay.
And again, you have the educational seminars by organizations. So I think I know the intent of that, which obviously the commission belongs to some organizations and attends seminars, and certainly that should be appropriate when it's not a party presenting on a potential issue that could come before the commission.
Well, I'll ask you and Mr. Mushin a question. What if the commission is extended an invitation, receives an invitation to visit a facility that's not a utility? Does not belong to a utility.
The way I read Act 41, that's not appropriate.
So would that be a meeting? If the commission were to visit Google, for example.
I think the commission would have to decide whether that's a utility facility.
But what if it's not? And what if what if a quorum of commissioners accept the invitation? Could that be considered a meeting? I think what you're saying is you don't think, not just Act 41, you don't think 58.3.260 allows the commission to receive an invitation to visit a non-utility, period, right?
My reading of the provisions in Act 41, that would not be one of the, I don't know if it's termed an exemption under Act 41. There are other things I think that are listed as exemptions, but I don't think that's the way that section is worded. I don't have it right in front of me, but I read it as site tours of utility facilities.
Mm-hmm. What do you think, Mr. Mushroom?
So I think it's subsection I, if I'm remembering correctly. So it says, notwithstanding anything in this section, or something to that effect, the commission may do a site tour of utility plant and other facilities. So if it is not a site tour, then that notwithstanding language then doesn't apply. So then I think you get back into the ex parte prohibitions. So it may be a meeting. It may, depending on whether there's a quorum. If it is a meeting, then you have to deal with FOIA and notice and all that. If you get past that, then the question I think would be: is it an issue? Will the commissioners be having communications about something that potentially could become an issue? So I think it would just have to be. Again, I think this is why it would be helpful to have another workshop to think through some of those things. Because if it's a meeting and it's open to the public, then other parties may want to be available. If it's addressing issues, then there's a way to do that with a non-quorum. There's just a lot in that.
Yeah. Because, the one thing that has not happened since that I can recall that the commission has ever held a briefing, allowable ex parte communication briefing in a location other than the hearing room.
I certainly am not aware of one.
Yeah.
But
Oh, we have two outside of okay. It's been a long time then. Ms. Wheat, our court reporter, has who would know, says we've had two briefings that did not take place in the commission's hearing room. There's a lot to think about, though, I think, when we have our follow-up. Not a lot, but I think that's another issue. If the commission, and obviously the notice had to state the location where we were.
So again,
we were at Salute of Shows.
But right, the question would be: was that open to the public or other parties to attend?
It was. They were.
I think there's a difference there. I mean,
Okay.
I don't know that even a tour of a non-utility facility is still appropriate under this. I'm not saying it is, but it would certainly help if it was something that was open to the public.
Yeah.
I think that at least introduces another factor for debate about whether it complies. Is that then an educational tour?
Yeah. So again, and I just want to be clear. I think there's ways to work through all this.
Yeah.
I just think there's a lot of with the allowable ex parte statute, it's pretty prescriptive and lays out the procedures and what has to happen, and so that gives us a good roadmap and has given us a good roadmap to work through these over the last 21 years.
Right.
With this, it's a little more vague. It doesn't mean that we can't figure out a way to do it. I think we can. I think it's just there's a lot of different factors that kind of have to. In my opinion, I think it would be better to work through some of those things on the front end and make sure that we're all kind of with the same understanding heading into those.
Yes.
So not at all trying to forestall or prevent the commission from doing it, because the statute allows what it allows, and we certainly will do, we'll play our role in that. So just want to make that clear.
Thank you.
Ms. Boyd.
Let's see. That's who is. Would you please identify yourself?
It's me.
Oh,
I'm right here. Michael Anselmo, McGuire Woods, outside counsel for Dominion Energy South Carolina, Inc. Period.
I thought you were virtual.
I did echo more than usual, but
okay, I apologize.
And I apologize since I have an annoying voice. Couple points from the company on this site visit. The Act 41 says conducting a 5830 of a utility or Santee Cooper facility under construction or attending towards our facilities. It's limited to utilities that are regulated by the commission.
Okay.
If you receive a request of I don't even know what to call it, something being built by a business that is not regulated by the utility, the commission should reject the invitation. So you don't have to get into the considerations of whether it's a meeting or FOIA. You simply can't do it. And for instance, the Saluda Shoals one you referenced, that was hosted by NARUC. So it is the educational opportunity exemption under 5830-260H, I believe. So that's important. But it is unequivocal that Act 41 limits what you can go visit to things under construction or other facilities of the regulated utility and Santee Cooper.
Okay.
So that alleviates a lion's share of the concerns, but to the extent we'll discuss it in more detail in another forum, we can expand upon it in writing as well.
Okay. Thank you, Mr. Anselmo. Okay, so Office of Regulatory Staff spoke, and so did Mr. Okay, so I think we're on Mr. Pelcher. Oh, is it time for a break? Do you need 7 minutes? Or 10:30? Is that good? Is everybody okay with us taking a break until 10:30, please? Okay, we'll start again at 10:30. Thank you. Thank you, Joe. Okay, everyone, we'll resume our workshop now. Mr. Hall, do you have some additional comments?
Yes, thank you. Just I had one last piece that I meant to mention on the responsive testimony. And that was just the point that it doesn't say responsive to surrebuttal. I think the legislature could have said that if they indicated. So that's one of the other concerns I had with Duke's proposal. But I did speak with counsel for Duke during the break and talked about that. Maybe we could work together and maybe come up with something we all agree with.
Okay. I know it's going to be beautiful, whatever the product is. Thank you. Okay, let's see. Lockhart. Mr. Pelcher, you spoke. We were just talking about the site visit, and you've relayed your comments as it relates to Duke Energy's comments. Yes, sir. I think I was recalling correctly because you mentioned the site visit and it was only for utilities, but you also encouraged us to include it on the follow-up agenda.
Yes, that was it. And well, thank you. Before the break, I was ready to give an amen to my colleague here on the left. Then I remembered this was the Public Service Commission and not a Baptist church, so I didn't do that. I didn't do that. But I think it's important that any role that the commission have here be bounded by the statute. And I would anticipate that when we have that follow-up conference, it will be when we talk about the rules, it will be done in conjunction with the statutes. Because I heard a lot of discussion here about how this should be applied. Some I agreed with, and some I didn't agree with, but not strong enough to, comment on it. But it did emphasize that we need to have a conversation.
Yes, sir.
Thank you.
Thank you. Okay, Mr. Gooding.
Comments at this time. Thank you.
Thank you, Mr. Gooding. Mr. Terani?
Just a couple.
Okay.
First of all, I want to agree with Duke's comments regarding 10385, 845, and witnesses being excused from the stand and being allowed to speak with counsel after their testimony is given. You get me? I see my shirt's unbuttoned. And everybody else dressed up for this one. And, last time I came, put on pants, did the whole thing. And anyway, however, in their language, I might go a little bit further.
Okay.
They said that a witness may be excused when he leaves the stand. I think if a witness is finished presenting their direct testimony, they're excused. It should be presumed. Because I would hate to have a situation where there's an oversight where for some reason, the chairman didn't say the magic words and then we're arguing over whether or not they can talk to counsel. If they're done, they're done. And that would be consistent with circuit court practice. And so I strongly agree with these comments. I think that's well developed there. On the verification issue, I had always assumed that what that language meant was in some cases we file, say, a petition for something like an expansion of service territory, or I don't, any number of these fairly non-controversial petitions by the utility that don't necessarily require pre-file testimony unless ORS has an issue with it or somebody else does. And filing the verification with the petition or the application is a way of expediting the proceeding and allowing the commission to go ahead and put it on the agenda. That's been the way I've used it in past practice, and it's never been a problem. I read that regulation to mean that.
Okay.
If the commission agrees, then I don't see any need to change it. I think that's the way it's been applied as far as I know.
Right.
It doesn't require a verification, just as we don't file verifications of pre-file testimony unless we want to enter it into the record without the witness swearing to it, like we do when there's a settlement agreement. So to me, I I don't think there's a problem there.
Mm-hmm.
I'm glad to talk about it further, but that's what it means to me, at least.
Well, and that historically, Mr. Terani, that's the way I've seen it used because, well, in part, if the attorney who's representing the entity or person who's filed the document, or the attorney is representing facts or provides facts that someone with the personal knowledge has given the attorney, then I don't know how the attorney can verify that because the attorney is representing someone else who has the personal knowledge, not maybe the attorney happened to be there, but I bet that's probably not within their job description to say that this pipe, is installed.
The Rule 11 obligation.
Yeah. Yeah.
That's filing a good faith pleading.
Yes, sir.
But so I just don't see a problem there. But if there is one, we can certainly talk about it.
Okay.
The issue of whether SIR rebuttal pertains to a new matter or doesn't is as old as time. I don't know that it can be solved in a regulation. Glad to talk about it if it can be. My question is more procedural. Will SIR rebuttal require a motion, or is SIR rebuttal subject to objection? In other words, who needs to do what? And that means a lot, because if it requires a motion, then we need to talk about what the responsive period for that motion is. And is there time for arguing the motion before the hearing? And in practice, what I've seen happen, and luckily I haven't been involved in any of this, but sooner or later, it could be. What I've seen happen is parties are going to the hearing, arguing their motions to strike SIR rebuttal, and not knowing how they're going to be resolved. And that's not really a very efficient way to do things. So I think the first step the commission really needs to answer is, are you going to file SIR rebuttal with a motion, or is it up to the other party to object to your SIR rebuttal is not appropriate? And then the second is, how do we develop the arguments before the hearing?
May I say something, Mr. Terani?
Of course.
I think what I heard today from the comments today, no one is suggesting so far that the clerk's office at the commission change the current practice of including a SIR rebuttal testimony deadline in the pre-filed testimony letter. I think what I heard is that if an opposing party has an issue with the substance of the SIR rebuttal testimony, that opposing party needs to file a motion to ask the commission to strike it for it being improper or whatever. That's my understanding.
That's what I want clarification on.
Okay. Yes, sir.
And I agree with the need for another proceeding to deal with the site visit issue. I haven't looked at Act 41 closely enough to have an opinion on its restrictions or non-restrictions and what you can do beyond Act 41. I would simply offer that there are utility facilities within the definition of the code, at least major utility facilities that are not owned by utilities.
Mm-hmm.
And if I don't know if a statutory amendment's needed, I don't have an opinion on that. But to the extent that the commission wants to visit a Google data center, I welcome that. I think it's a good idea. I think the commission needs the ability to educate itself on the matters it's considering, and to just tie it down to the utility. If we need to go back to the General Assembly, then let's do that. But so I'm not going to get in the middle of that fight. But I'm just saying, let's talk about it in another forum, and I won't drag things out here.
Thank you for your comments, Mr. Terani. Ms. Fox or
Ms. Boyd?
Oh, I'm so sorry.
Can I follow up and offer one thing
Sure.
Based on Mr. Terani's comment? And I do agree about the being excused from the witness stand, because it's up to to the alert lawyer to ask that the witness be excused right now. So I would suggest that we maybe revise what our proposed sentence said from the witness may be excused from the witness stand to the witness is excused.
Is excused. Okay.
And we can do that in follow-up
Okay.
comments, but I just wanted to sort of put that out there because I think the comment was well taken.
Okay.
Thank you.
All right. Ms. Fox?
Yes, we just have one comment on that same 845. I would just say that the current reg says while on the witness stand, a witness may not discuss the substance of the case. So most of us that have been practicing before the commission for decades always thought this was the rule. And so we do appreciate that there was a question that came up, and we appreciate that Duke is addressing that and clarifying that, because we thought that was the practice and should be the practice. And we also agree that it should be the witness is excused as opposed to may be.
Thank you. Mr. Richardson?
Piedmont does not have any specific comments, but certainly supports the company's written comments as well as positions taken today. So,
thank you. Okay. Mr. Terani, are you ready? And everyone, Ms. Mixon, Mr. Gooding, you should have a copy, electronic copy of the summary that was prepared for Nexus Water Company's comments, and Ms. McMillan distributed the others to the persons in the room. So, Mr. Terani, are you ready?
Yes, ma'am.
Okay. Would you proceed with your comments, please?
Mm-hmm. We have a general observation about procedural schedules, and that is that specifically with regard to rate cases, well, with any schedule, but with regard to rate cases, I'll get into how this can apply in particular, but there needs to be enough time between the testimony deadlines for discovery on the testimony.
Okay.
And I think if Act 41 says we need to have discovery at a schedule for discovery at each phase of the case, that has to be what it means. And I'll give a rate case as an example. We now pre-file our testimony with rate cases as an applicant. So then there'll be a schedule in which interveners direct testimony, or us as a party of right, file their direct testimony. That's really the first look we have at what they're going to say about our application. At that point, under the current rules of discovery, we can file discovery, and we would have, the receiving party would have 20 days to answer our discovery requests. So as somebody said earlier, there really needs to be adequate time between the direct testimony of the interveners and the rebuttal testimony of the applicant that allows the applicant to review the testimony, serve discovery, get answers, work out objections to answers, and then file their rebuttal. And in fairness to the interveners, the same thing needs to happen with regard to the applicant's rebuttal. Now, to get to all of this, I'm not sure it's always going to be feasible to maintain the current response times. And so 20 days in some cases may have to turn to 10 days. On the other hand, it may be reasonable to limit the number of requests that can be made. These things, otherwise, it's not workable. And one of the things one of the advantages of requiring applicants to file their direct testimony with applications was going to be that it was going to shorten, that it was going to minimize or reduce the need for discovery, and that it was going to allow the cases to be front-loaded. So if you don't have to wait on the applicant's direct testimony as you used to for, say, 3 weeks, then there's room to move that whole schedule up. And that will allow you to sufficient intervals between direct, rebuttal, SOR rebuttal leading up to the hearing. And that also addresses the issues that we're hearing about. Well, there needs to be time to analyze the SOR rebuttal. I'm suggesting that at least in rate cases, you have the ability to do that. Now, do the interveners need an opportunity to review the application and conduct their discovery and audit requests? No doubt. I'm not arguing with that. But, the timelines are what they are, and a schedule needs to allow for discovery rights. So that's our first comment.
Okay, Mr. Terraini, real quickly, if you don't mind, Ms. Purvis, would you display what I have here? I just want to get your thoughts, a visual for myself. So in a rate case, typically, when the application is filed, the direct testimony is also filed. So we're not going to use that as an example. So based on what you just said, you said there needs to be sufficient time after this, line 14. So if it's filed today, which is August 22nd.
Right.
What is the earliest, just a ballpark date, should the other parties, all other parties, discovery discovery deadline be? I don't know if that's worded right.
Well,
but yes, sir.
Yeah, I don't know. I mean, that's a good question. And also keep in mind that from the perspective of the clients I represent these days, I'm in a slightly different position than Duke and Dominion. They are very concerned about interveners' discovery. As a practical matter, I'm probably serving more discovery than the interveners. On the other hand, ORS is serving their requests under 58-455. So the discovery deadline doesn't matter to me as much. Because they're going to serve it, and it's going to be really dictated by the line. What is it?
15. I mean, the line 14 is all of the parties' direct testimony.
It's going to be dictated by line 14, right?
Okay. Yes. Yes.
I mean,
yes, sir. Yeah.
Yeah.
Because they're not going to know until 8.
They can serve. They've got to serve their discovery, and they've got to conduct it. They've got to get it done in time for the date on line 14, right?
Right.
So we can talk about that, but I don't know that from the applicants. I'm not sure how that works or how it's even relevant at that point, unless we're saying you couldn't wait until 8/21 to file discovery on the applicant's application.
Mm-hmm.
I mean, honestly, I found the Act 41 language a little confusing when it came to this phase of the case thing, but I'll let others talk about it.
All right.
My next issue though is from 8/22 on your schedule.
Oh, okay. Yes, sir. Yes, sir. Yes, sir.
Put that back up.
Yes, sir. Yes, sir.
See, from there, if I read that discovery, that testimony, I need time to read it, to talk about it with my clients, and to serve my interrogatories and requests to produce. And under the existing regs, there's 20 days to answer them.
Mm-hmm.
That schedule, so as a practical matter, either the 20 days get shortened or the period between line 14 and line 16 gets lengthened.
Mm-hmm. Mm-hmm. I'm following you.
That's all I'm saying. And the same would go for SOR rebuttal leading up to the hearing. All of this argues for moving things up. That's what I'm getting at.
Moving pre-filed testimony deadlines up.
Yeah.
Yeah. Okay.
Now, when moving on, regarding South Carolina Code 103-832 subpoenas.
Yes, sir.
I propose that you modify the existing rule, that you have it conform to what we do with depositions, that you need leave from the commission to serve a subpoena. Nobody, it's been correctly observed, we don't have a lot of subpoenas, but it has occurred to me in looking at this that boy, could we. And especially with the number of pro ses that you have at the commission, I think there's an opportunity for some real mischief in serving subpoenas and then causing people to move to quash and et cetera, that we ought to go back to the way it was done before the rules were amended, where you had to get, and I mean the circuit court rules were amended, you had to get leave of the court. And I think you ought to have to, just like a deposition, you ought to have to go to the commission and apply for it and explain why you need it. So I'll leave that at that. I agree with comments that have been filed, and I've said something to in our comments echo the fact that if customer complaints are going to be carved out of 103.833, it begs the question of what governs them. And until we develop a separate procedure for customer complaints, you shouldn't take them out of the reg. And you shouldn't exclude them. A customer complaint is a contested case. It may be a different type of contested case, and it begs for different treatment, in my opinion. But without prescribing that different treatment, we need to keep it in. I don't know if 103.833 was meant to read the way it does now, but we suggest, and I'm talking about 103.833C, under special circumstances and for good cause shown, I would add responses to requests for production of documents and things must be served in accordance with the Commission's discovery procedural schedule for a contested case and request. Or maybe, I don't know, maybe I'm wrong with that, but I'm throwing it out there. I thought in the context it meant to be that. With 103.835, there's existing language in there that I frankly don't know what it means. Where it says this section is subject to the limitations of section 58.455. 58.455 provides a mechanism for RS to propound requests for discovery and requests for production of books and records, et cetera. We can argue about what that means on a different day, but I don't know that 58.455 says anything about the Commission's discovery procedures. So I'm not sure that what that language means or if it needs to be in there. And those are my comments.
Thank you, Mr. Tarani. Mr. Mustian?
So just a couple of comments. So, with respect to Mr. Tarani's comments about the deadlines, and I certainly understand that. I think, so rate cases is obviously the biggest issue where this comes up. Over the years, entirely appropriate, but as we factored in time for the commission to draft its orders, time for the hearing, those dates have gotten, on the front end, have gotten further and further compressed. Mm-hmm. And I think some of that's just a function of what it is. I will say from the discovery standpoint, when we receive discovery, while we may have a right to respond in 20 days, typically we do our best. If the company has asked for 5 days, 10 days, we do our best to respond in that time frame. I understand not all parties may do that. I'm certainly not speaking for them, but we recognize the compressed time frames, and so we do try to expedite our responses where we can. And I don't know what really the answer to the discovery issue is. Excuse me. I know that in the cases that we've seen since Act 41 has gone into effect, I do think the parties have tried to work together to come up with a feasible schedule and try to accommodate some of those types of issues. But you know, that is probably a larger question that needs to be delved into a little bit more. You know, with respect to 103.835, the section is subject to the limitations contained in 58.455. You know, I've always viewed that as a recognition by the commission that ORS's ability to request books and records and other documents is separate and apart from discovery. So I think that's in there for a reason. And then I know Mr. Trini didn't address it in his comments, I don't think, but he did in his letter. So all I'll say is, you know, we view discovery under the Commission's regulations different than what our statutory authority is under 58.455. And so, you know, we feel like given our mission, given our responsibilities to investigate and inspect, you know, that specific duty that the General Assembly has given us, and the mandate that we have to investigate, and the rights and responsibilities we have under 58.455 is separate and apart from the Commission's discovery. I think that's borne out by a couple things. With Act 41, it talks about schedules for discovery. It doesn't reference 58.455. In fact, Act 41 didn't make any changes to 58.455. And 58.455D specifies that that our rights under 58.455 do not, that nothing in that restricts our ability to serve discovery. And so I think that's the recognition by the General Assembly that where we seek information under 58.455, that's different from Commission discovery. So, anything else you want to say? So I think that's all we have on that right now.
Okay, thank you. Mr. Anselmo?
No, we're good.
You're good? Okay, good. Thank you. Mr. Trawick or Mr. Welber?
Just briefly, we certainly recognize this issue that's come up with 58.455, and we always work with ORS on it. I would like to point the party's attention to B2 and of that same statute, and it says, if such an inspection, audit, or examination is part of a contested case proceeding, the Commission shall address objections to information sought by the regulatory staff in the same manner in which it addresses objections to discovery issued by the parties to the contested case proceeding. So that does suggest that there are some discovery parameters there, and that perhaps there could be deadlines and things of that nature. I don't think that's a question we have to solve today, but you know, that I don't think there's a clear dichotomy between discovery and AIRs.
Discovery, and what was the last thing you said?
Sorry, audit requests.
Audit requests.
Yeah, thank you.
Thank you. Which part? Mr. Hall.
Nothing else in response to Mr. Trini.
Thank you. Mr. Pelcher.
We have nothing else.
Nothing right now. Mr. Gooding and Ms. Mixon.
No comment. Thank you.
All right. Okay, that's Mr.
Ms. Boyd?
Yes, sir.
May I?
Yes.
May I clarify something?
Yes, sir, please.
Just a couple of points, since they were newly raised. First of all, I want to clarify that I agree with Mr. Muschin that ORS has been cooperative in past cases and in producing discovery on an expedited basis when needed for purposes of rebuttal testimony. So I have no issue with that. That's certainly happened in the past, and I expect it to continue in the future. I'm just pointing out a structural issue.
Okay.
And we could even have good faith disagreements about whether the discovery is appropriate. And it's not necessarily restricted to ORS. I didn't talk about 58.455 B, but I just because I thought it was kind of beyond scope of what the nature of the conversation. But all we said about 58.455 B was that the commission has authority, as Mr. Trawick pointed out, to restrict and govern discovery of ORS under that statute. We really didn't express an opinion one way or the other about whether Act 41 restricted it or not. I think the authority already exists. The fact that the General Assembly saw a need to govern discovery in these proceedings, I think suggests that maybe they were contemplating the exercise of the Commission's existing authority, not necessarily expanding it. So just to clarify our position on that, we think the Commission has always had this authority. It's just there's never been much occasion to use it, but it certainly could be.
Thank you, Mr. Turing.
Ms. Boyd, could I just respond?
Yes, sir.
And respond to Mr. Trawick. So, I did just want to point out, he is correct that 58.455B, let me get back to it, I apologize. B2 talks about, addressing objections to discovery. I agree, that's what the statute says. B also says at the top, limiting the inspection where arbitrary, capricious, unnecessary, unduly burdensome, and unrelated to the regulatory operations of the public utility. So I think there's that's fairly specific as to when under that construct under B when that applies. The other comment I would make is with respect to objections, the way that I would if that were to occur, that would be a specific situation where a request has been made, a party has raised an objection, and then that's addressed by the Commission in that context based on those specific facts. What's the request? What's being sought? What's the scope of the proceeding? As opposed to a Commission regulation that establishes a blanket restriction on ORS's abilities under 58.455. Under that circumstance, the Commission would be by regulation restricting what our authority is under statute. There's also a statute in, I think it's 58.4, can't remember exactly what it is, where it talks about the Commission cannot oversee or
ORS is performance or what you do as an agency. Yeah,
right.
Supervise.
And so I think that comes into play as well. So just wanted to raise that. Well.
Okay. Thank you. Ms. Fox, did you have anything in response to Nexus Water Group's comments? No comments? Okay. And then Mr. Richardson.
No, ma'am. Thank you.
Okay. All right. Mr. Turaney, we're going to move on to Ms. Fox and Mr. Wright. Is that okay?
Yes, ma'am.
All right. Ms. Fox.
Thank you, Ms. Boyd.
Yes.
First, we had the concern about the contested case not including individual customer complaints, and we appreciate the Commission staff striking that because I think that would have been problematic.
Yes, ma'am.
Another issue that we have is Act 41 obviously was focused on the energy industry and on electrical utilities, and the issue with the discovery schedule in 835 being required to be filed. Act 41, well, let me back up. Act 41 deals with electric utilities primarily, and I think the focus was very much on rate case type proceedings. It does say contested cases, but even then it's limited to contested cases. So I think we have to be careful about not trying to apply a one-size-fits-all solution to something that was intended to really be specific to electric utility contested cases and primarily rate cases. For example, you have like telecom certification proceedings, and sometimes they're contested and sometimes they're not, and most of the time you don't know they're going to be contested when you file the application. Right. So this sort of phased-in discovery is a little bit burdensome when you don't really have an idea of if there's even going to be opposition to an application. And and you don't know what the pre-filing deadlines are going to be and everything else. And sometimes in those cases, in CLEC matters, there is a statutory time frame for the commission to act there too. So you do have that sort of condensed schedule. Mm-hmm. But anyway, we believe that there should be a little more flexibility. In most cases that are filed with the commission, even if they are contested, it may be a fairly minor thing. And a lot of that can be handled with a status conference, and 99 times out of 100 in a lot of these things that I've seen, there is no discovery. So it seems like jumping through some hoops if you're going to require this kind of a discovery schedule to be filed with every application. It's a little bit of make work. So we propose that the must be filed with the application in 835 be changed to May, and that there be a little bit of flexibility to determine whether or not in a given case, first of all, determine is it a contested case? Yeah. Second of all, determine if it is a contested case, is discovery necessary? Mm-hmm. And then the third decision would be, if you're going to have discovery, is the standard practice today, which is, it's kind of, you do it whenever, as long as it's completed at least 10 days before the hearing. Is that sufficient? Because discovery is going to be fairly limited. All of those things, there just needs to be a little bit of flexibility so that, and maybe another solution would be May, and in the case of electric utility rate cases, shall file with the application, if that's the major concern. It just seems to us that there should be some flexibility built into that.
I hadn't even thought that far about like as you said, most of our telephone certification hearings are not contested. Mm-hmm. And I hadn't thought about that. Thank you for bringing that up, though. That puts another spin on everything. Yep. Because cases may not, tariffs are filed, maybe it's a new tariff. And under 103, I think it's 804 representation, there's some cases that are listed that are not considered contested. Right. You know what I'm talking about? It just says you don't have to have representation, legal counsel that doesn't have to file. But thank you. I don't want to prolong that. I hadn't even thought that way, the way that you're have thought about it.
Yeah, and I may file an application that I think is, easy peasy, not going to be contested, and then you get an intervener. And,
right.
And then at that point, it becomes a contested case. But when I filed the application, it wasn't. I wouldn't not have considered it a contested case.
Yeah.
So just some flexibility there would be appreciated to take that into account.
Yeah. Okay. Was that I'm looking back at your comments. 835. Okay. Yes, I didn't know. Was that? I couldn't remember if that was the end of Ms. Fox and Mr. Wright's. No, they had some other ones, I think. 103, 846. You mentioned changing the wording that slightly.
Yeah, I think that was addressed in Mr. Anselmo's comments, where I think. Well, at the very beginning. Of this, you said you were going to take another look at that. So,
yes, ma'am. Yeah. Okay.
I think that's all we have, Jocelyn.
Okay, thank you so much. All right, Mr. Mushton, any comments?
Just generally?
Generally, yes.
No, ma'am.
Okay. All right. And what about you, Mr. Anselmo, at this point? And what about you, Mr. Trewick? Nothing right now? All right, good.
We're fine with May.
Okay.
To
May.
give flexibility to the other utilities.
Okay.
For purposes of proposing a schedule.
All right. Mr. Hall.
Yeah, I would agree with that including May seems appropriate. I think you should, if you don't happen to file a discovery procedural schedule, that your case should be dismissed or anything like that. So, and it's ultimately up to the commission to issue the schedule anyway. So.
Okay. All right. Let's see. Thank you. Mr. Pelcher. Nothing. Thank you so much. Ms. Mixon or Mr. Gooding?
Nothing from us this time. Thank you.
Thank you. Mr. Terraini?
Agreed with Ms. Fox's remarks.
Wonderful. Mr. Richardson?
Nothing here.
Nothing right now. Okay, so everyone, so where does that leave us now? Now we've reviewed the comment. I've called on those entities who filed like written comments, and others have provided oral responsive comments today. Of course, you have the right to file anything that you'd like to between now and the follow-up forum. At our follow-up forum, at a minimum, what staff will do is we will compile comments again, everybody, and include, based on our discussions today, another document with, for example, the regulation that Ms. Fox mentioned, changing the word must to may in 103.835. So it'll be a clean version, basically, including considering all the comments that have been filed. So that will be one of the agenda items. 103.842, I think it's D. That's the new section that we're talking about for comment schedule. So that's going to be on the agenda. New customer complaint procedure. So we're going to have to put our heads together, staff will have to put our heads together about what that should look like, and then you all will throw darts at it. And then last, we're going to talk about site visits and educational tours, please. Does anybody think that agenda is too long?
I just had one question.
Sure.
Are you intending to sort of take back the comments you've heard today and then incorporate the ones that staff believes should be included? So that's what we would see. We're not sort of rehashing everything here today. You're sort of going to take, okay, we agree with broadband, we'll put Greenwich Bay, we agree with Duke on this. Okay.
Yes.
Then it's still a lot, but I think it's
just too
necessary.
Long. Well, what I can do is we can focus on the revised reg suggestions at 1, and then the customer complaints and the site visits and educational tours at another one. Is that more palatable? Because we need you be able to think and not feel overwhelmed. Yes, Mr.
I think splitting it up makes sense.
Splitting it, that's what we would do.
And maybe even the site visits and customer complaints. There's a lot.
Yes, sir.
To talk about in those.
Yes, sir. Okay, well, we'll have 3. We'll have 3 follow-up forums, everyone. And of course, what was I going to say? The commission staff does not vote ultimately on the regulation. So that would, when we provide you with the revisions, please provide any additional comments that you have a right to. I don't know how else to make that plain. Okay. Have I left anything off? Does anybody need to say anything else today?
Quick question.
Is that Mr. Gooding?
It's Michael Anselmo from McGuire Woods, representing Dominion Energy, South Carolina, Inc. period.
Coming from the ceiling.
I didn't want, just some clarification about the additional topics that you sent out.
Oh, yes. Yes. Thank you. Because that I will include. Okay, so it depends. So remember, we want to talk about verification. For example, what is that necessary? Is that sentence, a verification under oath shall be required if facts are alleged to be true within the knowledge of the person filing? That's currently included in our regulation. So what does that mean? When should it be applied?
You want written comments on that? Or
if you would like to before our next forum, yes, sir, please.
Okay, I can provide some now, but the question that I actually had is your topics 2, 3, and 4.
Yes,
2 is existing reg.
Yes, sir. And so it's an existing regulation. Let me tell you what I'd like for everyone to consider here. Consider whether or not that sentence should begin by stating the presiding officer may fix the time, or an interested person may file. The question we would like for you to answer is should that regulation allow someone, if they want to file a proposed order without the commission initiating that request, should they be allowed to? Does that make sense, Mr. Anselmo?
Yep, that helps. And then
the next page.
Yep, 3 and 4. That's existing statute.
Oh, light facility. We'd like for you all to please think about a time period, because the commission has 60 days to issue an order. So when should the commission consider placing this item on the agenda? We don't want to keep badgering you about when or you understand what I mean? So please think about, should it be within 3.5, 4 weeks after that the commission should expect to place the light facility application on its agenda for a decision? And last one is very easy. I wanted to make sure, number 4, that the commission doesn't have a role in this bearing their costs. I know that sounds weird. When I say this, like, interveners don't owe the agency any money under this statute, potentially. Or is that between the intervener and the utility? Is that what that section means? Interveners shall bear their own costs of participating in proceedings before the commission. For example, right now, Mr. Pelcher is aware, we have a fund where the commissioner's staff, we keep timesheets on Santee Cooper's cases. So Santee Cooper basically pays for its participation in commission dockets. And I'm just wanting to make sure that this section doesn't involve the commission. We're not supposed to be keeping any records. Okay, that's all I wanted to make clear. So 4 is off the table. We still need to discuss, please, topics 1, 2, and 3.
Okay.
Okay?
Thank you.
Thank you for bringing that up. I forgot about that. What if we include topics 1, 2, and 3 then on our first forum with the revised regulations only? And then number 2 will be customer complaint process, and number 3 will be the AEP. Not AEP, but site visits and educational tours. Okay? We appreciate all of your participation and your efforts and energy today. And we do have another forum that we're going to start as soon as Ms. Purvis can reset everything back in the back for our live stream, everyone. So if you're participating in 2025 192A, I'll see you shortly. And if not, I hope you have a great weekend. Thank you.